Texas, every Tuesday from 5 p.m. to 6 p.m. Central Time, we do bring in immigration updates. Emily, what do we have today to discuss?
Yeah, today we want to talk about what happens when you have an H-1B visa stamp in your passport that has your old employer's name on it, and now you're working for a new employer. Can you use that old stamp? When can you not use it? What are the rules on that? And we also want to update you on the 540-day automatic EAD extension that we currently have for H4 EADs, assuming they have the extended I-94, as well as the GC EADs. That is going to be reducing back to the 180-day auto extension, October 26th, right around the corner. So what things do you need to be aware of? What are the important dates to know to make sure you can maximize your automatic extension of your EAD? Another common question that we get right now is, once I've moved out of H-1B status, maybe I filed a change of status to H-4 or B2 after a job loss, or I've left the country. How do I get back to H-1B? How do I reinstate that? So we'll talk about ways that you can transition back to H-1B after you've left that status. And then also want to talk about changing status to B2. If you use the USCIS online system for that, what do you need to know about that? What are the potential hurdles in that process?
Emily, I want to go with question and answer with some of the things so that I can extract some lot more information from you. The first thing is that, let's say, for example, my H-1B with company A stamping is expiring in September of 2024, which is 1 year from now, and I am not working with that company. I'm working with company B, and the H-1B with company B is expiring in September of 2025, which is 2 years from now. If I go outside the country, let's say if I go visit India and I want to come back, will they allow me to come back on company A's H-1B stamping, even though I don't have company B's H-1B stamping in the passport?
Yes, absolutely. Thankfully, you can use company A's visa stamp as long as you have a valid I-797 approval with an I-94 on it for company B. You do need to show both of them at the port of entry, because sometimes when you're coming in and you only show your passport that has the visa stamp in it, they may only give you an I-94 till the end date of your visa stamp, even though you have an I-797 that extended your status. And you are eligible for that extended status. So make sure you provide your approval notice along with your visa stamp, and double check that you were given the correct expiration date on the CBP website.
What if I'm in India, Emily, right now, and I haven't been to USA from past 1 year? My H-1B is expiring with company A. I'm in India right now, and my company passport visa is expiring with company A in September of 2024, which is 1 year from now. And I get the H-1B approval with the council processing, not the I-94, 797A I-94, with the council processing with company B, and it's going to expire in August of 2026. Don't I have to go to passport stamping before I come to USA?
No, that passport stamp is still valid. So the H-1B stamp that's in your passport remains valid until it expires, even if you're no longer with that company. So when you do have a new approval notice, even if it's for consular processing, you can use the old stamp plus the new approval notice to come back into the country and regain your H-1B status. Well,
let me twist a little bit. What if company A has withdrawn my H-1B and the
I knew that question was coming.
USCIS has confirmed that my H-1B has been withdrawn. That means the September 2024 stamping company A has withdrawn the H-1B, is no longer valid. Can I still come back on the visa?
Yep, absolutely. Sure? When you have the approval notice with company B. Yeah, so when a company withdraws an H-1B, they're withdrawing the petition, the I-129 petition. That does not impact the visa stamp. So the visa stamp, again, remains valid until it expires. And so if you do have another employer that's sponsored you and you get that approval notice, as long as your visa stamp with the old employer has not expired, you can still come into the US using the old employer's stamp and the new employer's approval.
One thing that we want you guys to be very careful is that when you enter into the United States, please check the I-94 when it's expiring. in the scenario where I explained it, make sure that it's expiring on the day your company B's H-1B is expiring, not on company A's H-1B is expiring. And as soon as you enter into United States, if you see that your I-94 is expiring based on company A's H-1B though, okay, you need to contact an immigration lawyer. There are easy solutions. People do mistakes. They only show their passport visa. As Emily has pointed out, you need to show them the H-1 approval of the company B. If you don't show the H-1B approval of company B, you will be in trouble, and if you notify your immigration lawyer, there are very many easy ways to solve it. But if you let the I-94 expire, you will be in trouble. Anything else, Emily?
No, next up, the 540-day rule. So if I have my green card EAD that's expiring September 15th, and I have filed my I-765 to renew it, and it's still pending, and I cross September 15th, the old rule was my EAD card is automatically extended for 180 days, 6 months from the date it expires. And by the end of that point, I should have my new EAD card. So what is the new rule now, and when does it go back to the old rule?
The new rule, USCIS, because they were delaying a lot of these EADs, people like Stephen Brown, they started suing USCIS. For that reason, I guess they have come up with the new rule called that if the EAD is expiring, as long as you file the extension of the adjustment of status EAD. Now, we're only speaking of adjustment of status EAD. If the adjustment of status EAD, you file the extension, and the extension is filed before the existing EAD expires. At this point of time, because of the new rule, they can work for a period of 540 days. That means in the case of September 15th, 2023, if the EAD is expiring and you already filed an extension, you got the receipt notice, then people can work for 540 days after the September 15th of 2023, which will be somewhere around March of 2025, not 2024, Emily. However, this rule is sunsetting. We call it a sunsetting on October 26th of 2023. Now, if people file the extensions before October 26, 2023, they can avail the 540-day rule. Now, if they file the extension after October 26, 2023, they come into the old rule, which says that they can only work for 180 days, which is March of 2024. March of 2024, because you said that is expiring in September 15th of 2023. So 180 days, somewhere about March 14th or 15th of 2024. Until that period of time, they can work. Now, if the EAD by any chance is not approved by, I'm sorry, let me take back something. If they apply the extension after October, it's 180 days. I take back. But if they apply before, it's 540 days.
All right. Now, how is that rules? You mentioned that for the AOS EAD. How is it different for H4 EADs?
Now, for the H4 EAD, though, by applying the extension, either under the old rule or the new rule, you cannot work unless your H4 is extended. There are a couple of ways the H4 can be extended. People can go outside the country, get the stamping, and come back. Sometimes they can go to Mexico. They can come back. They can show the H1B approval of their spouse and get the I-94 extended without the passport extension. And in that case, when they file the EAD extension, though, under the new rule, they can work for 540 days after the EAD expires. But their I-94, which is H4, must be valid. Irrespective of the EAD extension, their I-94 should be valid, though. In the case of the AOS EAD, all they need is the EAD extension to be pending. But in the case of the H4 EAD, not only the EAD must be pending, their I-94 can be extended. We have made very many videos how to extend the I-94 without the EAD extended by either going outside the country to get the stamping, or they can go to Mexico and extend it with the automatic revalidation by showing their spouse's H1B approval. There are two different ways that they can do that. And that will be 540 days. But if they file their extensions after October 26th of 2023, Emily, then they will be only eligible for 180 days, not 540 days. This rule of 540-day rule is sunsetting on October 26th of 2023. Anybody who's filing EAD extensions afterwards, though, will be subject to only 180-day rule, not 540-day rule. Now, luckily at this point of time, Emily, we are noticing that the EADs, adjustment of status EADs especially, though, they are coming within the proper timing, though. But when it comes to the H4 EADs, we may or may not see them coming in a proper timing. So people need to file these applications way early because it's only 180 days. It's not going to be 540 days.
So for someone whose AOS EAD is expiring maybe next year, do they need to hurry up and file their renewal before October 26th, or are they relatively safe waiting and filing within the normal 6-month window?
You're speaking of the adjustment of status EAD or H4 EAD?
Adjustment of status.
At this point of time, Emily, if they file it within the 6 months period, though, they seems to be safe. Now, I can change my wordings later on because we are seeing the processing times anywhere between 3 months to 6 months for the adjustment of status EAD extensions. So a person can file the EAD extension 6 months before the EAD expires, and they have 180 days after the EAD expires. So they have a period of 1 year to get the EAD so that their employment will not be interrupted. Now, please, I advise all the people, try to file it as early as you can, okay? Don't wait. If your EAD is expiring on a certain date, don't wait until the last day to file it. File it within 170, 180 days. That is the period of time that you need to file your adjustment of status EAD extension so that you don't have any interruption. Now, I know some people, Emily, that will say, okay, I have an H1B, I have an H4 EAD, I don't need this one. We still advise strongly people to file the adjustment of status EADs because you never know. You may lose the job. The new company may not want you to be employed on the H1B. So you may want to have this adjustment of status EAD. File it anywhere between 180 days to 170 days. That's a proper time. Now, even if your lawyer wants to file late, you can choose to go with your own lawyer. You don't have to go with your company lawyer to file the adjustment of status EAD.
All right. Now, how about people who are on H-1B or were on H-1B, they suffered a job loss, and maybe they filed a change of status to H-4 or a change of status to B2, and let's say it's still pending, and now they found the new job. What is the process for them to get back to H-1B? Are there any special things that they should do to try to get that approved faster?
If their H4 or B2 is still pending, Emily, previously, especially when the B2 was pending, USCIS says that since your interim application is still pending, or they call it as a bridge application, is still pending, though, they won't approve the H1B with the change of status. Now, they switched the rule somewhere about in January or March of 2023. Now they are saying that even if your B2 is pending, though, they are going to approve your H1B with the I-94, most probably adjudicating the B2 application to, and sometimes directly giving the H1B with the I-94. So people don't have to leave the country to switch back to H1B. A lot of people also ask question to me, Emily, do they need to go through the lottery system if they move to H4 or B2 to come back into H1B? The answer is, if you have not completed the 6 years of the H1B, if you have completed the H1B and got the I-140 approval, you don't need to go to the lottery system in the next 90 years. Absolutely, you don't have to.
All right. And then should those people, let's say you file the change of status back to H-1B, can they start working immediately? or do they have to wait until it gets approved?
Unfortunately, since you're switching from either B2 application or H4 application to the H1 application, it's considered to be change of status, not change of employer. So you're not eligible for the rule where it allows you to work as soon as the H1B is filed. You have to wait until the H1B is approved with the I-94.
So it's best to file in premium processing for those cases.
Right.
Now, what about someone who, used up their 60-day grace period and decided to exit the U.S.? Can they still come back in H-1B status?
Absolutely. As long as they didn't complete the 6 years, or if they have completed their 6 years of H-1B and their I-140 is approved, they can come back into United States at any point of time in the next 90 years. Why do I keep on saying 90 years? Is people will ask, can I come in 1 year? Can I come in 1.5 years? Can I come before my passport visa expires? Can I come after passport visa expires? Can I come after the H1B expires? There are so many different scenarios. You can come at any point of time into United States back if you have not completed the 6 years of H1B, or if you have completed the 6 years of H1B I-140 approval, you can go to your home country and come back. However, you need the H1B approval to come back into United States. And if your passport stamping is expired, even with the previous company, then you have to get the new stamping. Now, if the passport stamping with the previous company has not expired in H1B, you actually don't even need to go for H1B stamping. You can just come on the I-797 approval with the consular processing without going to stamping.
And so there's no rule anymore that you have to file within 6 years of when you first got counted.
There is no rule that the next H1B, when you transfer from H4 to H1 or B2 to H1, or you're coming directly from India to here, the next H1B, since you are already been counted to the H1B, there is no rule that says that it has to be filed within 6 years. No. I only put my own rule saying 90 years because I don't expect people to live that long.
All right, moving on to filing a change of status to B2. So for people who are nearing the end of their grace period and still looking for the job, USCIS did come out and say that filing a change of status to B2 is an option for people to continue their job search. And there are 2 ways to do it. You can either file it on paper and mail it in, or you can file it online through the My USCIS account. Now, if you file it online, you actually can't work with an attorney on that. So attorneys, if you're working with them, will have to file on paper. And also the online system doesn't allow you to include family members in one application like you can on a paper I-539. So it ends up costing more to file it online if you have family members joining. What are some of the other issues you've seen with people that use the online system?
A couple of things I noted, Emily. People are getting confused. They don't give an option what status you are in. They give option of H1B1, which is not H1B. That's the most common. People are panicked. Pick the H1B1, guys. It's not a problem. We have done that every time. No problem with any of those things. Couple of things. I don't have an AN number. What do I do? I don't have a USCIS account number. They're asking that question. You can leave that blank. Not a problem at all. One thing is that try to file it within 60 days of the within the 60 days of the last pay period of time, though. Don't wait until after you complete the 6 years. Irrespective of some deficiencies Emily has pointed out, still filing online is much better. You may have a problem with the form, you may have a problem with the check, you may have a problem with the mail, you may have a lot of other problems. Normally when you file online, if there is any problem, it identifies it. It doesn't take your application. If you don't pay the proper fees, it doesn't take your application. So it's better to file online. There are a couple of things that I noted down in the application is that, hey, what is the start date that you should put? You should always put the start date within 60 days from the time your last paycheck. That's one thing. And until what date I should have it effective. We recommend it should be within 6 months from the start date, though, not more than 6 months, though. Please make sure that, because B2 is normally issued only for 6 months period, you try to keep it within 6 months. Oh, I filed my I-140 application. How can I file the B2 application? Not a problem. We have had many people file the B2 application. They have to indicate that they have filed an immigrant application. They have filed an immigrant petition. It's not going to affect you in getting the B2. We have never seen that any B2 getting rejected, though. once the B2 is filed, Emily, surprisingly, if you file manually as compared to when you file online, Emily, we're getting the biometrics notice very fast. We're getting the adjudication of the H1B, B2 application very fast as compared to manual filing. Anything else, Emily?
One question I always get is there's a question on the I-539 that asks, have you been employed since you were last admitted into the US? And so for someone who's on H-1B changing status to B2, you would answer that yes, because you are employed on your H-1B. And then it says, if you've answered yes, go to the very last page of the form and provide an explanation. And they ask, and everyone always asks, what do I need to say? Do I need to provide the company name, the address, my job title, my salary, my start date, my end, all of those things. So just know that when you answer that question, yes, and you are authorized to work, you can just say, I've worked pursuant to my H-1B status. You don't have to give all the details and your salary and your start date and a drop of blood and a finger. Well, you do have to give a fingerprint, but you don't have to give that much information there. So don't worry about that question too much. It's more relevant for, I think, other types of cases where that's more important.
One couple of other things is that do you need to provide the travel tickets? We don't. Do you need to provide the financial information? We don't normally. Do you have to give an explanation though? Yeah, that would be better to give an explanation. You can always consult a lawyer. I normally tell people to fill out the entire I-539 form to see what are the things that you have any questions about other than what I told you, and or even the ones that you have if you want to answer differently, and you can always contact a lawyer and they can give a proper information where, you know, what explanation should be given. Anything else, Emily? I have a couple of main questions that need to be asked about the visa bulletin issues.
Nope, we can go on.
Is there any chatter that you have seen in Washington, D.C. recently with regards to the visa bulletin where the 56th congressman has written the letters to the administration, and they ask the question straightly to the administration? The Congress is not able to pass the legislation for whatever reasons. Why doesn't the administration make it current? Is there any discussion on that?
Yeah, so interestingly, there was a reporter that kind of asked for an update to the press secretary for President Biden, and the reporter was very thorough in the question, knew a lot about the situation and the purpose of it. And, you know, unfortunately, the press secretary's response, I think she also was familiar with the situation, but basically said that's Congress's job. So you need to talk to Congress about that.
The Congress is telling, the Congress, 56 congressmen told that, hey, you know, why don't you do your job? And these people are telling, why don't you do the job?
Exactly. Yeah. So definitely not a good sign for that particular, you know, provision. Doesn't mean give up, but yeah, I don't know if it's going to happen for the October visa bulletin based on her response.
But we still recommend people to write letters to the administration to put a pressure on the administration. The draft of that is provided at the below video link. We expect everybody to write letters to the administration so that the priority date can be current. The filing dates can be current and they allow the file, because the reporter asked very good questions, Emily, that they said that people can be doing business, people can have flexibility in travel, people can have flexibility in employment, people can have flexibility in buying the homes. He has very nice questions, though, and the answer from her is, oh, yeah, put in the Congress. Please, we expect all of you guys to put pressure on the administration to make current. Let's go to question and answer, Emily.
All right. So a question from David. He's got his 485 filed, and the L1B extension has also been filed, but it got a request for evidence. The company doesn't want to respond to that RFE. What are my chances to continue to live in the U.S. waiting for the EAD, but that's not expected for another 3 months. So one thing with an L1 extension and also for an H1 extension, it does provide automatic work authorization for up to 240 days after your current L1 expires. So it may be beneficial for the company to delay responding to the request for evidence to allow you to use that automatic extension of your work authorization until you can get your EAD based on your 485. If that's not the case and they decide we're going to withdraw tomorrow, and you don't have the new EAD yet, the pending 485 does keep you in a authorized stay. So you can remain in the US based on your pending 485, even if the L1 is withdrawn, but you can't work because you don't have work authorization once there's no L1 and you don't have the EAD yet. So you do have the option of remaining in the, but you can't work until you get your EAD.
Question from GK. Is a green card holder is planning to return to US after 6 months. What documents he needs to carry? I would recommend that you carry that you have paid the income tax returns in the United States. If you have a lease agreement, if you have a house mortgage, if you have a job, you carry all those information with it. I would strongly recommend that if you don't have a lease agreement or house here, that you are not maintaining residence in the United States, or if you have not filed income tax returns for the past 2 years, please contact an immigration lawyer. People may ask the question, oh, the IRS rule says that if you don't make more than X amount of money, which I think is about 10,000, please, don't quote me on that. But if it's less than 10,000, you don't need to file an income tax return. That is not true. When it comes to the green card holders, everybody has to file an income tax returns. And what if I have only zero income? Can I file the income tax returns? Yes, you can put everything zeros and you can still file the income tax returns. So if you haven't filed income tax returns, if you don't have a lease agreement, you definitely need to contact an immigration lawyer.
Emily says, you see EB3 Rest of World becoming current in October, given that it was current in mid-2022. Can we expect that? So as Raul always says, we have a very hard time estimating visa bulletin. We predicted it wrong so many times. So my best guess is I would expect EB3 Rest of the World to become current in October, even though the filing date is not showing that it would become current in the September visa bulletin. I think USCIS or Department of State will move that date forward so that it can generate enough filings so that they have a full year to process them. And so, yes, I do expect it to become current. That's my guess, though. We could always be wrong.
Question, can we use the income money earned in USA as the EB5 funds? Absolutely, you can. No problem with it. And it's more easier to use the funds that you used in USA because it's easier to track. Because when we do the EB5, the main thing that we need to look into is that the money that you have earned is come from a legal way. So if you have the income that derived and that you have the sources from USA, it's so easy for us to show it. Here is the income tax returns. That's it. We're good.
Robbie says, can I work on the GC EAD but travel using the H4 visa stamp? Assuming that your spouse also has valid H1B and is maintaining H1B status, yes, you can. And then once you come back into the US, if you start working using your GC EAD again, then you're no longer in H4 status, but you can use that stamp to enter if your spouse is maintaining H1 status.
Pujita is asking the question, can I start an LLC on H4 EAD? Absolutely, you can. No problem with it. Now, here's the next question, is that what happens if my H4 EAD extension doesn't come on the proper timing? Pujita, there are many different ways right now to avoid the gaps, though. They have given a provision where if you file a H1, H4, and EAD together, they will approve the H1 and H4 and EAD together. So H1B can be filed in premium processing. You buy one, you get two free, which is H4 and EAD free. So you can do that. Now, if that fails, because there are some not so good employers that will say, we're not going to file the H4 and EAD along with the H1B. Even in that case, there are some exceptions. Where you can file the H4 and EAD extension, you can travel to Mexico and use your husband's H1B saying that, hey, look, my husband is extended for the next 3 years. I want the I-94 for next 3 years. And you have the 540-day rule right now. It may go back to 180 days. Either way, you will be employed for a period of time, and the gaps can be avoided. So there are very many creative gaps to be avoided. Now, we want people to be entrepreneur. We want people to make money. I mean, of course, the taxes will be collected. Of course, we get a part of that too, in some way or the other. So yeah, you can be an entrepreneur, especially in H4 EAD. Right now is the right time to do it.
Sri Harsha says, what are your thoughts on EB2 NIW? I have my I-140 approved with the 2019 priority date. Am I eligible to apply for the EB2 NIW on my own? So yes, assuming that you meet the requirements for NIW, you can file on your own and port your 2019 priority date. One of the main benefits for someone who might already have an EB2 I-140 approval is that by filing it on your own, your green card is no longer tied to your employment with that particular employer. So you kind of become a free agent in terms of being able to get the green card, even if you leave your current employer that has your regular EB2 I-140. For someone who does not already have their own I-140 approved through the normal PERM process, some of the benefits of the NIW, especially if your company is not willing to sponsor, is that you can sponsor yourself. And once you have that, it allows your spouse to be eligible for the H4 EAD. And again, it allows you to kind of take that green card process with you as you move companies, so you're not tied to a specific company.
Question from Krishna. Can my wife work on different state on H4 EAD? Will there be any impact on the I-485 filing? No, she can work. She can work in a different state. Absolutely not a problem for her to file the 485 application. We normally, when we file the 485 application, what we indicate on the 485 application is that she has two addresses, which is your address and the address where she is living for work purposes. You know, people travel for a lot of period of time, and people travel for long periods of time. They will be away from the spouses. Now, all we need to prove at the time when you file the 485 is you're genuinely married or not. And typically, that's not a major issue. When you've been married for such a long period of time, that's not a major issue. We never faced any problem, and people are living together, living separately.
Swati says, I got my H1B selected in the second lottery and I'm on STEM OPT expiring December 2024. When and what should I inform to my college? So assuming that your H1B is filed as a change of status, you don't really have to proactively inform your college. Once the H1B is filed, the receipt information automatically gets entered into the SCIS system. So they will have access to that. Once your H-1B gets approved and on October 1st, the SCIS system normally has that information and they will complete your student record and you will then be in H-1B status. So there's really nothing that you have to inform to your college except for you have to complete the ending 24-month STEM extension evaluation if you are leaving before the 24 months of your OPT. But most of all of that happens automatically.
Chintan is asking the question, is it okay to leave within 6 months of the I-140 approval if the HR says they would not be withdrawing the H1B petition? Well, that's your call though. The rule says that the company should not withdraw the I-140 within 180 days. Otherwise, you cannot use that to file the H1B extension to file for your spouse H4 EAD. So if you trust them and you think so that they're not going to withdraw, that's fine. But that's your call because we can't tell that you can trust them.
SP says, I'm currently working on H4 EAD, but the H1B has been picked in the lottery. Can I get the H1B petition approved and still keep working on the H4 EAD? There is a way to do that. And so what we would suggest is when the H1B is being filed, it should request a change of status from H4 to H1B. And then once that's approved, let the change of status take effect on October 1st. But if you then want to go back to H4, you can do it by traveling to Canada or Mexico and take advantage of the automatic visa revalidation. That allows you to go to either Canada or Mexico for less than 30 days, and you don't need a US visa stamp to get back into the US. You can then show your H4 I-797 approval notice. It has your H4 I-94 on it, your spouse's H-1B approval notice to show your spouse is maintaining H-1B status, and be let back into the country with a new I-94, putting you back in H4 status. Then your EAD remains valid and you can keep moving on the H4 EAD going forward. The reason I suggest getting the H-1B change of status and letting it actually take effect on October 1st is because that allows you to be counted in the cap so you don't have to go through the lottery again in the future. If you just got a consular processing H-1B approval but never get the H-1B stamp, you're technically not counted in the lottery yet. And so for any employer to file for you in the future for an H-1B, you would have to go through the lottery again.
Can I file a concurrent H-1B without notifying my primary employer? Absolutely, you can. You don't have to inform the current employer when you are filing the concurrently filed H-1B. Now, this is where he's speaking about he's working with company A, and he also, in addition to working with company A, he wants to work with company B. Company B can file a concurrently filed H-1B. He can work for two companies at the same time. Under the immigration laws, though, he's under no obligation to inform the company A about it.
Shiva says, my visa is till September 2025, but my passport expires on September 25th, I'm assuming 2023. So they gave an I-94 till September 25th, 2023. Now I've transferred my H-1B to another company and it's pending. So assuming that you've already gotten your passport renewed and then you file the transfer to another company, you're fine. So because you filed that H-1B transfer before September 25th, when your current I-94 is expiring, your new employer requested a change of employer and an extension of status. And then because you have the passport renewed, they're able to get a 3-year H-1B approval. And so you can continue working with company B that filed the transfer while it's pending based on that.
I lost my H-1B job. How to switch to H4 in USA and apply for H4 EAD immediately using my spouse's H-1B? This question comes from RK. So I don't know if your spouse I-140 has been approved. If your spouse I-140 is approved, you can file H4 and EAD together. But if your spouse H-1B is not approved and the PERM is not pending for more than 1 year, and then the spouse is not in the 7th year, no, you cannot file H4. H4 EAD is only for there whose spouse I-140 is approved under very limited circumstances when they are in the 7th year of H-1B, because the PERM is taking a long time, they can get the H4 EAD. Now, one other thing, can the H4 EAD be granted immediately as soon as they file the application? No, it takes a time for you to get the H4 EAD, even if your spouse has an I-140 approval.
Rajiv says, if an employer applies for the green card for a student, F1 student with their OPT, and they're from India, what would be the status of the person after the OPT expires? And what if the H-1B does not get picked? So for someone from India, assuming that you're going through the PERM process for your green card, your company is filing the labor certification, they may have been able to file the I-140 and get that approved before your OPT expires. But because your priority date is not current, you have to have a way to maintain some sort of non-immigrant status until your priority date becomes current. Typically, that is by changing status to H-1B, because the H-1B allows you to keep extending beyond the 6-year limit while you're waiting for your priority date to become current. If you're not selected in the lottery for the H-1B, then you need to look at what are the normal options for people who don't get selected in the lottery. You can continue your F1 studies. You can change status to some other type of visa that you might qualify for. You can look at nonprofit H-1B employers to at least be able to work for another company while you're waiting to get selected in the lottery with the company that sponsored your green card. If you're married, you can file a change of status to an H4 if your spouse is on H-1B. So not great options, and there's no option for you simply because you have your own approved I-140 that allows you to just stay and wait. You've got to continue to maintain some sort of non-immigrant status.
a question with regards to can the I'm on STEM OPT. My company is offering to file the PERM. Will there be any problem if the H1B is not selected in the lottery next time? The GC, the PERM and I-140 though, especially if you are from India, is not going to give you an immediate benefit. You can't stay in the country, you cannot work in the country because of the GC filed, the PERM application filed. Now, and even if you get the PERM and I-140 approved, you cannot work on that because your priority date is backlogged significantly if you're from India. Now, if you don't get the H1B, you will have to move on to another other college, or you'll have to keep on go outside the country, or if you have an H4 option, you have to move. But the GC EAD will give you benefit in the long term, but it doesn't give you the benefit in the short term.
Tanupriya says, I have my green card, but my dependent spouse's 485 was denied, but it was an error by USCIS. For filing the I-290B, and the spouse doesn't have any other visa, last paroled in using AP for the 485 that was denied. Is there any way for her to legally stay? So simply filing the I-290B does not provide any status for her. However, if the I-290B does result in the 485 being reopened, then she'll be treated as if the 485 was never denied, and her stay will be valid the entire time she remained in the U.S. I generally recommend, if it was a USCIS error, contacting the ombudsman of USCIS to have them look into the file, including filing the I-290B, because they have been able to get cases reopened faster than just simply waiting for the I-290B to process. Litigation may also be a faster option than the 290B as well. So those are things to consider, but assuming that the 485 really was denied in error, once it's actually reopened, she'll be treated as if the denial never happened and she was in status the whole time.
Questions with regards to these visa stamping in United States. We haven't heard any official information yet, though. We are expecting it by end of this year, probably by October or probably by December or maybe January of 2024. We're expecting visa stamping to be done within the United States. Now, when they do it, though, would they do it for all the people? We are mostly expecting, at least in the initial stages, though, if you already have an H1B, they probably will do the extension. If you already have an H4, they will probably do the H4 extension. That's my prediction. That used to be the case back before in 2003, about 20 years ago. It used to be the case. So that's what we're expecting when it comes to. So if you're an F1, if you change the status to H1B, would they do the stamping? Most probably not. That is my guess. Hopefully I'll go wrong.
Pallavi says, can someone on a cap exempt H1B visa work part-time? Yes, so any type of H1B can be filed for part-time employment. If that's your only employment, then you may have to make sure that you are at least making enough money and working enough hours to financially support yourself. So that can be an issue raised, but otherwise, there's not really any problem with a part-time H-1B. It just has to be specified on the LCA and in the I-129.
Does the RFE and medical or 485J, does it means the visa is allocated? No, it does not. We do get a lot of RFEs for the medicals. We get a lot of RFEs for 485G. We get a lot of interviews for the 485. That doesn't mean that their visa is allocated. They are just pre-adjudicating the application to make it ready for you at a later date, but it doesn't mean you have visa number allocated for you.
Kaluru says, how much time is it taking to change status from H4 to F1? And can my kid do an internship while the F1 is in process? What are the documents required for the F1? So F1 change of status now has a premium processing option. So you can pay that additional fee, and the processing time is 30 calendar days. So that's helpful, but be aware that those 30 days of the processing time start ticking only after the biometrics have been done. So you can file the change of status from H4 to F1 in premium processing, and then whenever the biometrics are actually complete, from that point, count 30 days and you can get your F1 change of status approved. Internships are not possible while the F1 change of status is still in process, because at that point, the child is still on H4, and H4 is not employment authorized for a child dependent. Documents needed for the change of status to F1, your child needs to get the I-20 from their school. They need to pay the I-901 CVIS fee, and then they need all of their immigration documents, H4 approval notices, H4 visa stamp, I-94, passport, and then let's see, what else am I missing? I typically include proof that the family or the student has sufficient funds available to pay for their first year of school. There's going to be amount listed on the I-20. That's something that the school probably asked for as well. I typically submit that.
Pavan is asking the question, when my main employer files the H1B extension, does he need to know about the concurrent employment? No, he doesn't need to. You don't have to inform him.
Rajan says, will USCIS allow the use of the filing date in October 2023? You know, we've had these two charts going back to 2015, and historically, USCIS has allowed us to use the filing date chart for employment based in October each year. So I would anticipate that that will be an option. And then the June 1st, 2022 filing date for EB1 India, should that retrogress? Well, obviously the final action date is regressed till what, 2012 for EB1 India. I would expect that that filing date shouldn't retrogress. Hopefully the final action date will move back to 2022 in October.
Emily, there was some discussion about the visa stamping website. Are you aware of it? That things were not working properly?
Yes, they moved it to a new system, and the system is very glitchy, very difficult to complete the DS-160, very difficult to schedule the visa interviews. I can't remember off the top of my head what specific problems people were having, but yes, it is a very frustrating system, even more so than the old system.
Brenda says, my employer letter has my current role with salary, has also generic statement. Company may not be able to make a statement regarding the employee future of continuous employment. Is that okay for the 485 interview? I don't like that statement in there, though. I mean, why do they have to make a statement? No employer can guarantee the future. They don't have to put it on the paper, though. That looks very odd that they're putting it, and it may negatively affect you in the 485 interview, especially if they are making a statement that they cannot make any statement with regards to the further future of our continued employment. That's a very odd statement, though. I would like that statement off from the letter when you go for the 485 interview. If not, you can try to see if you can find another job to go for the 485 interview. If that interview letter has been seen by the officer, I don't know. The officer might take it very negatively.
Clevy 26 says the employer contact, the HR person that signs the paperwork, has changed while the PERM is pending. Is that a problem? Is there anything I need to do? Nope, no problem at all. You just want to make sure, or the employer needs to make sure that they still have access to the PERM account, or that they're having those emails forwarded. But once the PERM approval is issued, the new signing person for the company will simply cross out the old person's name, handwrite in their name, and sign it, and you're good to go. Nothing that you need to worry about.
RK is reporting that his spouse's I-140 is approved, which is very good. We discussed about filing H4 plus EAD. If your spouse I-140 has been approved, though, and if you're considering options of B2 or H4, please file H4 plus EAD. I also recommend that you file H4 plus EAD together. Otherwise, it's going to delay your EAD application. you can always contact our office. We'll be able to help you out. You can always send an email to info@rnlawgroup.com so that we can help you out on that process.
Ram says, my H-1B was approved in consular processing with no I-94, and that I-797 has expired. Can I renew it or transfer it from India with the same or a different employer? It depends. If this was your very first H-1B that is subject to the cap, when you get an approval for consular processing for a cap subject H-1B, you're technically not counted in the cap yet. And so you can't use that to file with a different employer because you're subject to the cap. If, however, this was maybe you've been on H-1B for 3 years and you tried to file a transfer and it was filed late, and for that reason you got the consular processing approval, that means you're not subject to the cap. You've already been counted. You've already used 3 years of your H-1B status. That employer or any new employer can at any time file a new H-1B that does not have to go through the lottery to recapture your remaining time towards your 6-year limit. And also, if you have an approved I-140, then the 6-year limit can be extended beyond, even if you're outside the country.
Pavan has this question. If he has the current employment until December of 2025, which is approximately around 2 years, and the concurrent employment is only for 1 year, does he need to leave the country to extend the I-94? No, he does not need to. You have an I-94 with the current company until December 2025. After the concurrent employment is over, and if you don't want to continue with the concurrent employment, you can just stay in the country and do nothing until December of 2025. Of course, 6 months before December of 2025, you need to extend your H-1B, which you already know what to do about it.
David says, for year 2025, will the H-1B lottery filing fee increase? And do we expect fewer filings and more chances for legitimate people to get an H-1B next year? The filing fee, the registration fee is expected to increase. There is a proposed regulation that's already been published, I think, to increase it to $215 or $250, something in that range. And that regulation is supposed to be final in February, which means it should, or I'm sorry, in December, which means it should take effect in February in time for next year's lottery. Will there be fewer filings or better chances for legitimate applications to be selected? I think that depends on what other steps USCIS takes to fix the registration system. Simply increasing the registration fee from $10 to $250 is not going to be enough to combat these duplicate filings. They need to make major changes to the system. Now, what might cause fewer filings is if we actually see people go to jail or criminal actions being brought against people who did these duplicate filings, particularly the employers. Hopefully employers and applicants learned their lesson from this year that these duplicate filings should not be done, and that hopefully will make a difference, but it's ultimately going to require more from USCIS to change the system.
How long does a PERM is taking now to get the approval? It's taking about 11 months right now to get the PERM approval. That's about the time that it's taking. For those people who are contemplating and filing the green card, guys, give it about 2.5 years at least from the start to finish to get your I-140 approval, assuming you're going to file the I-140 in premium processing. Because there's a prevailing wage process that's taking about 8 months, and the green card, the PERM is taking about 11 months, plus there is an additional period of time for the advertisement and cool off. So it's definitely taking more than 2 years to get the PERM approved nowadays, and I-140 approved.
Sam asks, what are the typical reasons for I-485 denial under the employment-based category? Well, I would say the number one reason is the I-140 gets denied, and that's for people who filed the I-140 and the 485 concurrently. Once your I-140 is approved, there's generally not a lot that goes wrong with employment-based 485. Beyond that, it would be if there's some ground of inadmissibility, maybe you had unlawful presence that was triggered, or unauthorized employment.
Domestic violence?
Yeah, domestic violence is a big one. Other criminal issues. Those are the main causes. And one of the other main causes is USCIS error. I think I see more of those than anything else, which we are
can we safely state, Emily, about 90% of the 485 denials we see is because of I-140 denial?
Yeah, oh yeah, I would say so.
Yeah.
And we see so few 485 denials in the employment-based category as well.
Except the, when we file I-140 together, I-140.
Mm-hmm. Yep.
Questions with regards to can I file the I-140 while I am on the H4? Will it cause any problem for the I-140? No, yeah, you can file the I-140 while you're on H4. You can. A lot of people move from H1B to H4, and while they're in H4, they can file and get an I-140 approval. Move back to the H1B again if they want to. Absolutely, they can.
Santosh says he visited Mexico by land on a business trip and came back by land, and he sees his I-94 reflected with his arrival date into the U.S., but the departure date is missing. Do I need to get this fixed? No, you don't need to get it fixed. It's not a big deal. We do see weird things in the travel history that just don't show up, and there really is not a method to fix them. The only time you need to get something like that fixed is if your arrival does not give you a new I-94. But in this situation, you're talking about just the departure date being missing on your travel history. No need to worry about that at all.
Just a little bit update on the CSPA, Child Service Protection Act. The question is coming from Srini Shishan. If the child has never filed a 485, could we use the new rule though? The main question here would be that, would the child be able to file if the filing dates were correct? That's the main thing though, is that could the child have filed? Like, for example, if the priority date is 2016, it was never current. Now, can we froze the age of the kid? No, the answer is no. But if the priority date is in 2014, the entire family filed the 483 application, this kid did not file it, thinking that he's not going to be eligible, I strongly recommend you to contact a lawyer so that we can take a look into it, if we can file the 485 or reclaim the date for him. Can we track the PERM application? Normally, the employer can only track the PERM application. It's not something that the employers share that information with you. So it has to be through employer's lawyer. That's the best way of tracking the PERM application.
It's that Nitra says, I'm on H4 and H4 EAD and also have a GC EAD. What is the process for moving on to the GC EAD, and will it impact my spouse who's on H1B? There is no process. You have 2 EAD cards in your hand, and you can just say, you know what, tomorrow I'm going to start using this other card. That's about it. It all just kind of happens in the air. You don't actually do anything. Just next time you do your I-9 re-verification, if you're with the same company or if you change employers, you would show them the GC EAD in order to show that you are work authorized, and it has no impact on your spouse since the H-1B is its own independent. It's not reliant on you in any way.
What's the way of extending the I-94? Do we have to cross the border? Depends on the scenario. I mean, if you are thinking about H4, there are many different options available to extend the I-94. You can file the H4 along with the H1B and then get the H4 approved. So which I-94 are we speaking about? Is it B2? Is it H4? Is it H1? So there are, for each of those things, there are different options, Sonia. You have to tell me which I-94 are we speaking about.
All right.
I'm asking this question, can we go for L2 stamping in Mexico? Absolutely, you can.
I think we're out of time for today. So thank you everyone for joining us. As usual, we'll be back next Tuesday at 5 o'clock Central Time with more updates and answering your questions. Thanks for joining.
If you want to speak with me, Emily, or any of our colleagues, our appointment schedules are available. You can block a time that suits to you, where you can discuss the issue with me, Emily, or any of our colleagues. The appointment link is there in the video, at the bottom of the video.